Today is March 5th, 2026, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong-Motin. Every Thursday, Gene Lawler, Michael Schwimmer, David Schraga, and I are delighted to co-host another wonderful webinar for mediators, arbitrators, lawyers, and everybody who negotiates. As you know, there's no charge for these great webinars. We ask people to contribute to a food bank if they like what they see. And since we began the series in 2020, our audiences have been so generous contributing in honor of our great speakers. I think one of the best parts, one of my favorite parts of the webinar each week is when we announce the running total of just how much our generous audiences have contributed since the series began. Natalie Armstrong-Motin, would you please do the honors?
Jeff, it is absolutely my pleasure. We've raised nearly $1 million, which is tens of millions of meals provided to people who are food insecure around the world. Today's total is $940,974.42. Thank you, everyone who has donated time or money to your local food bank.
That is fantastic. And we are delighted to welcome another great speaker today, Ashok Ramani, the head of IP litigation at Davis, Polk Wardwell, a leading AmLaw 200 law firm. Ashok and I have known each other for a long time. I know him to be quite expert at mediation and negotiation as well as courtroom litigation. Ashok is the beneficiary of a truly extraordinary education. He received a bachelor's degree in economics from the University of California at Berkeley and a JD from Harvard Law School. Today, Ashok will be addressing us on the subject of lessons learned from Bet the Company IP litigation. Ashok has represented many of the country's leading tech firms in Bet the Company 8 and even 9-figure cases. The lessons learned from that are invaluable for us as mediators, and we need these lessons to talk intelligently to the lawyers in mediations and the clients about just what happens in case the case does not settle. Ashok, please tell us a bit about the food bank to which you would like people to contribute if they're in a position to do so, and then on with the presentation. The floor is yours.
Thank you, Jeff, first off, for the invitation. Very much appreciate it. And Natalie and others, thank you for not only arranging this, but making it possible to have such a terrific cause or set of causes be supported. So the food bank that I would ask folks to consider donating to is called the Samaritan House of San Mateo. It's a terrific food bank. My family and I, we live in the peninsula in the San Francisco Bay Area, and it's our local food bank, and we volunteer there every week. And they have some, not only do they help a lot of people who are suffering from food insecurity, which is unfortunately rising fairly dramatically the past 2 years or so, but they also are trying out some innovative new solutions. So something that my wife and daughter have been volunteering at, I think for about 2 years now, is something called a food pharmacy, which I wasn't aware of, which is the idea is that you introduce people who have high blood pressure, hypertension, and other similar ailments to different types of fruits, vegetables, and other foods, and you give them recipes that they might be able to use that they wouldn't otherwise know to prepare those foods for their families and to improve their health. So it's a pretty cool concept, and that's just one of the types of things that Samaritan House has been pioneering. And so if you see fit, a donation to them would be lovely.
Great. Thank you.
Jeff, I kind of would envision this as a little bit of a conversation back and forth. Tell me what would be most helpful for your audience to hear. I mean, look, I've been fortunate. I think I've been practicing now 28 years. I've tried 24 cases, and it's mostly jury trials, but a decent number of bench trials as well, and mediated probably 4 or 5 times that number at this point. And these disputes are 8 figures, 9 figures, and sometimes 10 figures even these days, more recently in the IP space. And so what would be helpful for your audience to hear, do you think?
I think the most helpful thing, Ashok, what is it that you wish mediators knew, or that you wish more mediators knew, that we just don't understand?
So let me start off by saying that I've been pretty fortunate in that I've had the opportunity to work with some really excellent mediators over the years. And look, the disputes don't always settle. That's how I ended up trying as many cases as I have. Uh, but I do feel like I've gotten to see some of the very best mediators work, at least from one side of the one of the many rooms. And so I think the biggest thing for the types of cases that I do, which are high figure IP and uh, other types of business disputes, is the best mediators are able to pretty quickly understand what the business dynamics are at play and take those business dynamics into account when figuring out how to try and cut through, what might otherwise appear to be a Gordian knot of a dispute between these often sophisticated parties. So maybe I can give you an example. I had a trade secret case a handful of years ago between two very, very large technology company competitors. And one had clearly taken improperly, had a former employee of the plaintiff steal a bunch of stuff, bring it over, and use it to set up a competing venture. So those facts were pretty undisputed. And so it was really going to be a fight about whether things were already out there and known and how much the damages were at stake. And we ended up using, I think, two or three different mediators over the course of that case. And unfortunately, the case didn't settle. But I do remember the final mediator who we used, unlike the prior two who just seemed to engage in kind of shuttle diplomacy. Okay, one side is here, one side is there. Let's see if we can meet in the middle, which for sophisticated parties like that isn't particularly productive or useful in my experience. But the final mediator we used actually spent the time to dig into the business situation in the market to figure out where it was that these parties were and how they were trying to position themselves in the near future. And that was incredibly valuable. And ultimately, the case resolved partway through trial, I think primarily because of the efforts that mediator took to really understand the business terrain. And that's something that I
So,
wish folks were able to do more often.
so let's dig into that a little bit, Ashok. Digging into the business realities and business considerations. The mediators don't really know that when they get the file because those considerations seem self-evident or different in every case with every company and even with the same company at different points in time. So first, I would imagine mediator, no matter how high status, needs to show a little humility in being willing to admit they don't know what they don't know. Can you comment on the attitude that you would like mediators to bring to the mediation in that regard, or perhaps others?
Yeah, I think you put it really, really well, Jeff. Look, it's true of all of us. After you've been doing something for some number of years and you feel like you've had some success, you maybe are psychologically unwilling to acknowledge that you don't know certain things that you might be expected to know. And I personally found the most effective mediators to be the ones that try and set the ego entirely out of it, and then come in with a real mental curiosity to learn more about the clients, ask questions that don't seem on the surface to necessarily be pertinent, about the client's business, what the client sees as their business challenges in the coming business year, maybe even in the near, slightly further out term, the next 2 or 3 years, in terms of strategic planning. And then when you have that information, because these are often large companies fighting with each other, you can often use that, I think, to help structure some kind of resolution. Because with many of these corporate clients, it's not just the individual case that's presently before them. These in-house legal departments are facing a lot of cost pressure. Many of them hear themselves described as cost centers, and having to pay lawyers seemingly ever rising legal fees year after year for these kinds of disputes can be difficult. And so having someone hear about where their business is focused and try and take that into account in formulating um, a resolution, I think can be pretty refreshing.
So let's talk about how mediators get educated as to that and how you as lawyers get educated as to that. Usually we get a mediation brief that doesn't talk about those kinds of things. It talks about the strengths and weaknesses of claims and defenses, the procedural posture of the case, history of settlement negotiations, that sort of thing. And then I think it's a standard of care for most mediators to have a phone call or a Zoom call with the lawyers before the mediation after we've had a chance to read the briefs. When we ask you, are there business considerations of which we should be aware? Are those things that of which you are aware, or are those things that mediators need to learn during the mediation when your clients, the business clients, are actually present with you?
So it's a very good question, and I'm looking at the chat here, and I see that there are some echoes of that question coming up here. So two different answers. If the advocate, the person in my position, is doing their job, they should already know what the business realities are for their client, because they shouldn't simply be viewing. Look, there's a tendency to view ourselves as gladiators. Look, we're going to put on the armor and we're going to go fight in the arena for you, and that's going to be that. I think that's pretty short-sighted, especially if you're dealing with clients and you want to have a long-term relationship with them as their outside business advisor, whether you're a trial lawyer or some other kind of lawyer. And so the outside lawyer, especially the lead counsel, should know the business realities facing the client and even facing the other side, at least as best they've been able to figure out over the course of the litigation. So I might encourage mediators to just ask more expressly, other than what you just said, Jeff, is a fairly standard question that I think can be open to interpretation. You might even ask, I'd like to hear what your business plans are for the rest of this year and for the next 2 or 3 years, and how those might impact any potential avenues to resolution in this case. I think being more express about that might save time, might even give you some information, in the brief, because I'm sure that all of you find it just as unproductive as those of us who prepare them sometimes, where the mediation briefs are just exercises in posturing, kind of chest bang, oh, we've got the strongest case, look at these facts, it's unbelievable. You're going to hear that from both sides, and it ends up kind of being a waste of everybody's time.
So those conversations, Ashok, I think will take place actually in the mediation, not just in preparation. That is when your business client is present with you. Do you want the business clients to have conversations with the mediator even before the mediation to clue in the mediator as to some of these deeper concerns?
I don't have a problem with that. I know different outside counsel have different views on that. Some people think, some lawyers in my position want to keep their clients, almost feel like they need to be chaperoned in any discussions with mediators. I don't personally think that's the case. Now, I might feel differently if the client is an individual or a business person and relatively unsophisticated, which sometimes unsophisticated about legal matters and litigation, which sometimes happens in these kinds of cases. But more often than not, if we're talking about a seasoned in-house lawyer or executive, I think it would be perfectly fine for them to speak with you guys ahead of time, without me present.
Even so, if a mediator suggests in a mediation, Ashok, can I talk to the chief financial officer, the general counsel by myself? You'd be okay with that?
Yeah, I'd be fine with that.
Okay. Well, that's a novel perspective. Very few, my experience, very few lawyers would say that, even though many times the business executives who you're representing are exceptionally sophisticated people.
Well, but that sort of ties back to a broader issue that I think tends to pervade my side of these cases. And by my side, I mean the outside, the lead counsel side of these cases is we often just view ourselves as the fighter, and we're myopically focused on trying to fight and get the best, squeeze the best possible outcome out of a given situation for the client. I personally think that's a short-sighted approach to dealing with client relations. I think it's clients have told me that they very much appreciate more somebody who can be that gladiator type when necessary, but more broadly learns about their business and is able to help counsel them about the business aspects of things broader than any one given case.
So do you find, Ashok, that your opposing counsel tend to be similarly statesmanlike in their approach, or do you find, even in these very high stakes cases, a lot of people with more of a two-dimensional, shall we say, gladiator mindset?
I more often see the latter. Occasionally, I have opposing counsel who are like-minded in their thinking, but more often than not, there are all kinds of potential reasons for that. I think sometimes the lawyers feel like they want their clients to think of them as the fighter and to maintain that persona at all times. Other times, I think in some smaller number of cases, the lawyers are worried that um, if the case resolves too quickly, they and their team are gonna suddenly have a big hole to fill in terms of work and revenue and all of that, which unfortunately is sometimes a consideration that we see um, in these matters. So I see it far less often than not. Jeff, I see some questions here that are really good. I wouldn't mind addressing some of
Yeah,
them.
why
So
don't you go ahead? Go ahead, Ashok. Pick and choose as you wish.
okay, so there's a question, and I apologize, I can't see the full names here. It looks like it's from Ed Timken, who says the mediator asked you for the business background and the realities and worked through them with you instead of just being a number runner. Yes, I would say that's true. I find that to be much more helpful than just having, what I think of, what I don't mean this to offend any of you, but I think the lowest form of mediator is someone who acts as an errand boy or errand girl running in between room to room, where the people in the rooms are clearly telling them, here's what you need to tell the other side. This is all that we're going to allow you to share going forward. And I think mediators have to exercise more agency than that for them to be productive and for them to participate in a useful way. So Ed asked another question. Can a mediator who is not an IP or patent person educate themselves? Absolutely. In settling these IP cases, I think very little about it has to do with the technology. To be sure, some of it has to do with the merits, but the merits in these cases, if the lawyers have presented the situation to you correctly, should be fairly easily understood. They have to do more with things about the potential damages exposure, the jury pool, etc. It's things that pretty much anybody should be able to pick up, and it has nothing to do with whether or not you have some kind of technical background or how to read a patent, for example. There's a question here from Dr. Lynn Duffy. Would you offer an initial meeting with each party individually to seek information? Maybe. I mean, I think you can ask more expressly for business considerations in your mediation brief. And then maybe at the beginning of the mediation, assuming that you don't have a joint session, but you start off with the parties in different rooms, maybe you just talk about it then. Because that might be, in my experience, that's something that the business people really like to talk about and feel like they add value on. And it's kind of the language that they're used to speaking. And so I think that would be good for even setting up rapport. So Alec Chapa, forgive me if I'm mispronouncing that, wonders, does the hovering attorney force all information between party and mediator through the lens of adversarial and legal dynamics by being there? Perhaps. I think there's actually something to that. I think that is sort of part of where the mediator can play a significant role, which is to recognize that and then perhaps try and minimize that impact or modulate it during the course of the mediation so that it can be used when appropriate. So there's another question here from David Schraga, who asks, how do breakdowns in the relationship with opposing counsel over discovery impact the potential for resolution in mediation? I find that doesn't have. I haven't found that to be a dynamic, at least in most of my cases. But my cases tend to be large enough where I, as the lead lawyer, am not often getting involved in the day-to-day discovery matters or even matters that go to court over discovery skirmishes. And so usually I find the case that's also true with my opposing lead counsel. And so we're able to sort of stay above the fray to some degree. So I think that can sometimes be a very toxic element, David, to be sure, in terms of the teams starting to really loathe one another when it's done incorrectly. But I haven't found that to be an impediment to potential resolution.
If I could just jump in, thank you for that. The lead-in question was, how do the discovery considerations in big IP cases just affect in general how you think about positioning a case for resolution? I mean, obviously, when you're in these massive disputes, the impact on the business, the scope of discovery, it's a massive consideration, right, in terms of how you think about things, I presume.
It absolutely is. Unfortunately, though, by the time we often get into mediation, whether it's court required or otherwise, much of fact discovery is done. Much or most of it is done, and we're in expert reports or we're teeing up summary judgment. This may be news to you guys, or maybe it's not. But I can tell you, for the past handful of years, I've been telling clients, if you want to take a significant patent or trade secret dispute through trial, it's going to cost you at least $15 million, and it's going to cost some in attorney's fees. It's going to cost somewhere between $15 and probably $23 million just for your outside counsel, not including experts, discovery vendors, etc. And so I don't know that all lawyers are upfront with clients about that and about what those costs are. But David, kind of using your point as a pivot, I think that there can be real value in trying to mediate some of these disputes early if there's a possibility that a settlement in that range or close to it could make the thing go away. Typically, that's not going to be enough for the types of cases that I'm talking about. I'm talking about maybe more in the patent context, a significant non-practicing entity suing a big company. There might be value in doing a very early mediation there, because the costs of defense have been rising. I'm sure you guys have been following the law firm economics articles, in the American Lawyer and Law.com and whatnot. Hourly rates at the biggest firms have all been climbing fairly significantly for the past handful of years, and that's just adding greater prices to resolve these disputes.
Ashok, let me ask a little more philosophical question, which is, you said that earlier you said cases don't always settle, and you said it in sort of a matter-of-fact way. So let me ask you about the attitude and mindset that you have when you come to a mediation vis-a-vis settlement. What are your real goals when you approach a mediation, and what do you want the mediator's mindset and goals to be as well, vis-a-vis settlement and other potential goals of the mediation?
So happy to answer that question, but let me get to the answer in a somewhat roundabout way, which is that when I take on any case, I tell the client from the beginning, we're going to take on this case from jump. We're going to be preparing this case for trial. And if you don't think there's the possibility of a trial, then don't waste your money on us. We're too expensive for you to be paying us otherwise. And so that's the mindset that we have as outside counsel. That's how we approach, and my team, we approach the discovery process when we are in the run-up through pretrial and trial. And so how it is that mediators can be most helpful in my judgment is understand that in a case, and this might somewhat contradict what I just said, but in the prior answer, but in a case where someone like me and my team is representing one of the parties, a cost of defense mindset from the mediator is not, whether we have the plaintiff or the defendant, is not going to be particularly useful. And so that's why, again, I think digging into the business situation on both as it pertains to the dispute, but even more broadly, I think would be the most helpful thing that a mediator can do. So another question from Timothy Olson, Jeff, that's kind of in line with what you just asked me, which is I'm curious to hear different examples such as mediator blunders, surprising outcomes, restored relationships. Mediator blunders, the biggest mediator blunder that I've encountered is being discernibly less than honest, shall I say, in what you're telling the parties, because we're usually able to figure it out. And so some mediators feel like it's their charge to, kind of put a thumb or a hand or a body on the scale and overstate or misstate intentionally what has been said in one room versus another room. And that gets figured out. Often that gets figured out during the course of the mediation itself, just because things sound off to one side. But then you have to remember that people are going to talk sometimes, and business people in particular are going to talk afterwards, and they're going to remember that, and they're going to remember that mediator acted that way. And we as people participating in mediation see that as a major breach of trust. So I think that's the biggest blunder. Surprising outcomes. So I had a mediation a few years ago with a very, very well-known mediator that I thought was going to be a complete waste of time. It was a massive trade secret case. Our client was seeking $1 billion. The other side had clearly stolen stuff, taken it to China to create a competing business. And so we went and we did this mediation, and we actually had a joint session at the mediator's suggestion, which I also think is usually a waste of time, because you then both sides get pissed off, and then you spend some of the rest of the day unwinding any damage that might have been done, has been my experience. But in this case, it was actually quite effective to have a joint session and it might be because they were relatively unsophisticated individuals who we were suing along with their new company, whereas my client was a very sophisticated, Fortune 50 company. And so I think it was quite helpful to have them hear a preliminary opening statement, if you will, from us. And to our surprise, late that night, the case settled. So that was a very surprising outcome. I mean, more often than not, I go into these things hoping for the best, but expecting that they're not going to settle, but maybe we'll make some useful progress for down the road. And that's typically what happens.
So, Ashok, what does useful progress mean?
It can mean a couple of things. One thing that I think of is you just get helpful information, potentially from just signaling in terms of if the parties start exchanging positions. But even more than that, just hearing from the mediator, and here's why trust in the mediator has to be almost sacrosanct, where the mediator shares, these are the concerns that are animating the other side here. Again, this usually applies more for competitor type cases, or an individual who feels totally wronged, as opposed to a non-practicing entity or something that is just set up as a litigation vehicle, where these concerns may not be as pronounced. But those two things I think are quite useful to come out of a mediation with, even if it doesn't resolve, to at least have some understanding of the other side's motivation, because we often don't get that once we're kind of in the fray.
The question that comes to my mind, Ashok, you're a trial guy, you're preparing for trial from day one. You've tried almost one case a year, which is extraordinary for someone dealing with the high stakes cases with which you deal. How do you get into mediation in the first place? What triggers it? What makes a trial guy like you initiate or agree to the idea that, yeah, this would be a good time to mediate?
So I like to think of there's an old story that I like to think of as someone who loves going to trial and is often hired and often brought in late to take over cases as they're going to trial when the client decides that their current counsel isn't going to be enough. I like to think of these stories from the Wild West, where, if legend has it, old gunfighters like Wild Bill Hickok, Billy the Kid, and others, they would do everything they could to avoid getting into a gunfight. They'd sit down, offer to buy the other guy a drink. round of drinks, see if they can calm everybody down. The reason being, you might think you're better, and maybe you're right, but that still doesn't mean that, you might catch a stray one day in that kind of profession. And so that's how I think of it, which is, I love going to trial. It's the reason that I do this job. I think I'm fortunate to have some success at it, but it's usually not helpful, especially for corporate clients, to be rolling the dice in that way, because inevitably there are wild card considerations that nobody can account for. And so that's why I think it's useful to go into mediation, because there are some cases that just cannot settle, but there should be a path forward in most of these disputes, as long as people can kind of put ego and emotion to the side, if that's possible.
So are you often the one who initiates the idea of mediation in your cases?
It depends. It depends again on the client's motivation and where the client's business is, and also how much they want to spend. Because, going to trial, as I've mentioned, is very expensive. And, doing fact discovery is expensive, but the run up to the pretrial process, so all the pretrial disclosures, motions in limine efforts, all that stuff, as well as then the prep for trial and the trial itself, that costs a lot of money to your outside counsel, but it also takes a lot of time of your internal witnesses. You're going to have somebody who's a significant executive in the company, sit as a face of the company for the entirety of the trial at counsel table. And so we're talking about real business opportunity costs. And so I will often raise with the client, look, should we see if there's a way to get this done, to at least explore it before you really embark on this massive expense. Back to the questions, Jeff. Richard Luttringer, sorry if I mispronounced that, asked, are there antitrust implications of settlements of IP disputes between major competitors when licenses may be part of the settlement package? There can be. That's a very good question. And you may have seen that there were what have been described as pay-for-delay settlements in the pharma space that resulted in a bunch of cases, especially out of the Third Circuit some years ago. So that can be the case. But as a general matter, there's a rule of reason application to determine whether or not a settlement of an IP dispute has any antitrust implications or concerns. So for the most part, not, but there can be some exceptions.
Ashok, let me take Ed's question and wrap it into a larger context. Kinds of cases you're dealing with, and really for any case, people have a wide variety of mediators from whom they can choose. There are the usual suspects, there's new people on the scene. You can go to magistrate judges in federal courts or other court personnel. What are the criteria that you use to decide from the wide variety of mediators you could hire, including mediators hired by the court system, mediators you hire in the private marketplace? How do you think about it?
So it's a very good question. I'm fortunate in that, the types of cases I do, there's enough at stake, and the clients are sufficiently solvent that we don't have to worry about paying. I know some of you mediation folks are charging $60, $70, even $80,000 a day these days for some of the cases that I'm doing. But we're able to, these sorts of disputes allow for that. So it's not really an issue. I prefer to go with private mediators when possible, as compared to a magistrate judge or some other court-appointed mediator. And it's mostly just a question of trust, because when the court has appointed, when there's a magistrate judge, I'm certain that the magistrate will be back-channeling with the district judge about what happened and who was reasonable. And in some cases, that's okay, particularly if I have an opposing party who I think is going to be unreasonable in the mediation or be perceived as such. It can be helpful for us to have that back-channeling back to the court. But more often than not, I think it's useful to just have a totally separate, off the books with the court, if you will, private mediation, so that people can just be a little bit more frank and not have concerns about things getting back to the judge. Because I've seen it where there's then a notice you can never know for sure, but you feel like there might be some impact coming out of it when you do a mediation with court personnel.
It's interesting, Ashok. Every time I talk to a magistrate judge, and I talk to them from time to time, just talking shop, they all swear on a stack of Bibles that nothing ever gets back to the district judge. And I see the grin on your face. It's a hard sell to lawyers such as yourself to believe that there's really nothing when even a facial expression or a bit of body language between two people can communicate a lot, even when words are not spoken. So it's an interesting distinction between the way the magistrate judges feel about it and the way that lawyers feel about it. So Ashok, let's talk.
I
Go,
will say, Jeff, just to answer, just to respond to that,
please.
definitely I can understand why my brethren feel the way that we do. There are some exceptions. There are some. I'll just give an example. Judge Joe Spiro and Sally Kim, who are two judges in NDCal, magistrate judges, who I think are particularly skillful settlement judges. And so, if I have the ability to get before them, because I know that I have seen them work, and I know that they're very good, then I would feel differently.
Great. So Ashok, let's talk about more about the attitude and the mindset. So picture a mediator who's been paid a lot of money, gets to work on one of these high prestige cases on which you work, getting towards the end of the mediation day, and there's something going on in the mediator's mind like, gee, it would really be great if this case settled today and the parties are far apart. What are the closing techniques or the pressure techniques that mediators might bring to bear, which might be effective? Which are the ones which are never effective and we should never think about using again? And what happens at the end of the day that works and doesn't work?
So I would say a couple of things. Two things come to mind that work, and one thing comes to mind that never works. Maybe we can start with the never works first. Sort of being intemperate or screaming at one side or the other. I know that there are some mediators, and this might be more of a relic of some prior years, who for show will engage in that kind of emotional type outburst. I don't think that's productive at all. And if anything, it just pisses everybody off, and then it causes you to lose the thread to some degree, as to where things might have been. The two things that I think can be quite helpful. One is, and this one might be a little bit counterintuitive. It's really, I think, kind for mediators to say that, I can be here all night to get this done. I find it to be more productive for mediators to say, hey, listen, you've got me until X time at the latest, and then we're done. Because I think that tends to focus people's minds a little bit more. In the same vein, I feel like 2-day mediations are largely a waste of time because day one tends to be taken with posturing and we don't get much done. I'd be curious to hear if you guys feel differently about that. But the second thing that I think can be quite effective is a mediator's proposal at the right time and introduced in the right way. Doesn't always work, but when the mediator appears to have dug in enough and have sufficient understanding of where both sides are, and ideally what the business terrain is, not only just between these parties, but in this industry, a mediator's proposal with some non-financial elements, I think, can be quite useful. And even if it doesn't drive things forward that day, I think it can leave the parties with something to think about that might get the thing done later with the mediators participating by phone or something, or even with the business people just talking.
Yeah, well, let's talk about the follow-up, Ashok, because you mentioned that cases don't always settle. We as mediators, we want to be conscientious, and all else equal, we would like cases to settle. At the same time, we do recognize that some cases just have to go to trial. What kind of follow-up do you appreciate from mediators? And what is just overkill, nuisance, get out of my hair kind of follow-up?
I would say that the follow-up that I appreciate is when the mediator goes dark for at least a handful of weeks, call it 4 to 6 weeks. Obviously, it's different if there's a mediation right before trial, and the trial is like 2 weeks away or something. But if we're talking, in the while summary judgment motions are pending or something like that, so there's still a little bit of a run-up through the pretrial process. Circling back with the outside lawyers, maybe 4 to 6 weeks later, just in a non-pushy way, just to say, hey, I'm just checking in. Now that things have kind of settled and you guys have had things have marinated for a little bit, just wanted to see if there's anything I can do to help here. I find that to be really, really helpful.
But let's just flip that coin for a second, Ashok. What is the kind of follow-up we should just not do? What will just make you think we're pests, we're too attached to the goal of settlement, and we should stay away from doing?
I would say it's not even so much the frequency of outreach, because I think checking back in every, call it 4 to 8 weeks or so, if things are still going on, in just a very unobtrusive way is perfectly fine. I think it's a mistake for mediators to check in and say, you really got to think hard about this because you're facing a lot of risk going to trial, sort of trying to unleash the parade of horribles type situation. Because at that point, I can say, look, yeah, I think I know I can game the likelihood of what's going to happen at trial better than you can. And so that's not particularly helpful. And if anything, that'll probably just piss people like me off.
And there's no sense in doing that.
No, it's not good for anybody.
No, not good for anybody. If there are more questions that I know, Ashok, you're loving the questions from the audience.
Oh
So
yeah.
I'm going to encourage people to put more in the chat here. So what are the kinds of in terms of your relationship with your clients at the mediations, what's the balance of power, if you will, in terms of who is actually conducting the negotiation, who is calling the shots? What might be helpful for mediators to know about what you guys are talking about when the mediator is down at the other end of the hall?
So that very much depends on the given client. So there's no one size fits all answer. When we represent individuals, or the client might be a CEO of a startup who has never had any experience with litigation, then I'm going to probably be running the mediation and the negotiation because the client just doesn't know and doesn't have the experience to know. Obviously, that would be ultimately I serve the client, and so everything that I do would really be as a recommendation to them. But if you have more sophisticated in-house counsel, like some of my clients have done hundreds of mediations and they've managed hundreds, if not over 1,000 major litigations, they are clearly running the show, with consultation with me as appropriate, I would say. But I don't know that my answer there, that might be idiosyncratic to me. There are some people in my shoes who take a very dictatorial view of this and say that I'm the outside lawyer, I'm the one who should be in charge. I think that's a terrible mistake. Again, because our job is to be a counselor to these business people. And so, that's the function that we should play.
Ashok, a couple of topics that we're just not allowed to conclude a webinar like this without talking about. One is, let's talk a little bit about AI and how you use it, how you would never use it, what role it might play in preparation or execution of a mediation strategy, and then the pluses and minuses of having mediations online on Zoom or one of the other platforms as contrasted with having them in person. Could you please comment on those topics?
Sure. Happy to take them both. Let me start with the second question first, the Zoom question. I think that the convenience that Zoom offers for mediations is terrific. And I think when you have experienced parties, particularly, say, for example, it's a mediation between a patent case with a non-practicing entity on one side, and they've sued 50 different entities, and it's just about making money for them. And the client is also at a they're very experienced with patent litigation. I think doing a Zoom mediation is completely fine in that setting. I don't see the need to do it in person. If there's a more emotional element, for example, it's a trade secret case where there's some allegation of betrayal or theft, or you have a patent case between competitors that don't have much litigation experience or really have a significant beef with each other beyond just an NPE is suing me, I got to take care of this type mindset. I would recommend that those be done in person, because I feel like there's you guys would have to tell me, but I feel like with good mediators, the in-person rapport is still very difficult to substitute over Zoom. So that would be my recommendation. As to AI, I think AI is going to have more than just LLMs, but even agents are going to significantly disrupt the way that the legal practice functions, especially at big firms. I don't think we're quite there yet for what we do. I don't see a meaningful impact of that on mediation anytime soon. The place that I see impacted is really more document review and identification of themes across sets of documents, potentially preliminary legal research, and then preliminary responses to written discovery. I think those are all going to be taken away very soon, probably in the next 18 to 24 months. And by taken away, I mean AI is going to be doing it, and it's going to. I think those of us in the legal profession, especially at big law firms in leadership positions, are going to have to figure out what it means to have a first and second year associate. We're going to have to just rethink the way that we've historically trained people, I think. So that's my thought on that one.
Reassuring to know that you don't envision having some AI avatar serve as your mediator, at least not anytime in the near future. So thank you for that.
I think you guys are in a similar position to me. I like to joke and say that, I think we're a long way off from, I don't think I'm going to still be practicing law when robots can start speaking for people in court. And it's probably going to be similar for the job that you guys do.
Everybody's blood pressure just went down a little bit, so thank you for that. We've got a couple of minutes left, Ashok, and there are some questions there in the chat if you want to take a look at them and pick and choose, answer any that you wish.
Happy to try and answer all of them. This question is an interesting one from David. What do you think the most effective in-house lawyers at a mediation do well? I think what they do really well is keep the business considerations in mind and figure out how resolution of the case is going to fit into their company's business mandate. Many in-house lawyers don't do that, unfortunately, in my experience. Not many, some at least don't do that. They become almost myopically focused, like the outside counsel, on this is the dispute, we're focusing on this dispute. And I think those that keep the broader business considerations of their company in mind at all times do a much more effective job, certainly in the eyes of their non-legal management. Dr. Lynn Duffy asks, what's one mediation that did not go well, and what would you have done differently? I've had lots of mediations that have gone disastrously. I'm not sure that I would have done all that much differently. I will tell you one story. I had one mediation for a big class action. It was filed in Texarkana, Texas, and we went to a very prominent mediator for this, and plaintiff's counsel insisted on having a face-to-face in the morning. And I told the mediator, I think that's a bad idea. It's going to be a waste of time. But he said they insisted on it, so we did it. And there were 10 different plaintiff's lawyers from different parts of Texas and other places who all insisted on introducing themselves for about 5 minutes, talking about their impressive resumes. It took about an hour, and it pissed off my client so badly that we ended up leaving the mediation at noon, just as I had predicted was going to happen. So one thing that I wish I had done differently maybe is prevailed upon the mediator what a bad idea that was. I mean, I tried, but I obviously didn't succeed. There's a question here about contingency and how does that factor into negotiations. Of course, it factors into negotiations significantly. A thing that we're seeing in IP cases, though, even more than contingency, is the prevalence of litigation funding. these days. And what that means is the waterfall that we're seeing, and we've seen over several years now, is the funder gets paid first, then the lawyers get paid, then the principal gets paid. And so, as a practical matter, that's why a lot of IP cases are going to trial these days, because there's just a structural impediment to settlement. I can give you an example. I had a case maybe 2 years ago where the other side was seeking about $200 million heading into the trial. The client had, I think, fairly reasonably valued the case at about 20 to 25 million, and that was what they were willing to pay to resolve it short of the trial. But we learned during the course of the mediation that because of this waterfall, the principal would only receive any money north of about $45 million in a settlement. And so they were not willing to settle for less than 55 or 60 million. And at that point, the client on my end said, let's just go try the case. And we tried it and we won it. And so it's interesting because there was real money that was potentially available to that principal, but given the funding mechanism, they ended up walking away with nothing.
So, Ashok, do your clients have arrangements and deals with funders yourself? Have you negotiated those deals with funders?
So I have not. Davis Polk, my firm, has a pretty strict view that we, as Davis Polk lawyers, don't get involved with funders, because many of our, we have many institutional clients, significant banks, but Meta, Comcast, a lot of large technology companies who have problems with funders too. So we just don't get involved with them. What we can do is introduce clients that might be interested in seeking funding to potential funders, and then have them kind of take it from there. So that's about as far as we go.
So has it impacted you yourself in negotiations? Have you come up against frustrating moments in trying to negotiate settlements because of funding arrangements your own clients have had?
Not that my own clients have had, but the case that the explanation that I just gave on the other side, it's fairly common these days. And that's why I think you're seeing a lot more IP cases and patent cases going to trial. I mean, they've always gone to trial, which is kind of what interested me in the area in the first place. But I think the fact that so many people have to get paid for there to be a satisfactory resolution these days means that in many instances, things are just not going to resolve. It just makes your guys' job harder, I think.
Yeah, it's really just writ large the problem or challenge that you have in contingent fee cases, which is the lawyer gets their share, then out of the client's share comes costs, then the client looks at what they're going to get and says, hey, what the heck, might as well go for the brass ring if this is all I'm going to get out of the thing. So this is a problem with which lawyers and indeed mediators have been wrestling for a long time, although the numbers have bigger numbers and perhaps more challenging situations in the IP context. Okay, Ashok, when I deal with AI, I always ask it, before I ask it for advice, is there one more question you'd like to ask me before you give me the advice I'm seeking? So let me ask you, are there some things that you were hoping that we would ask you, or some points that you're really eager to get off your chest in the last minute or two we have here?
No questions. I just wanted to say, I know that being in your role can sometimes be frustrating and irritating, but you guys do play a really integral role, in my view, in our dispute resolution process. So thanks for the chance to chat with you today.
Ashok, this was tremendous. Thank you so much. I know that I'll be contributing to the Samaritan House of San Mateo, California. Natalie has posted the link in the chat. I can see from the chat that some people have already contributed. I know many more will contribute as well. And Ashok Ramani of Davis, Polk Wardwell, Silicon Valley, thank you so much for a wonderful presentation. And with that, we are complete.